This is an amazing panel. I'm going to introduce everybody as quickly as I can in a moment. There's so much wisdom, so many clerkships with federal judges on appeals courts, so many book prizes, so much work. 100 years of scholarship, I don't know. Well, no, I didn't. That's not implying that half of them are yours. No, I'm not counting your Uncle Phil. But anyway, this is, of course, the year. Sorry, we can't move this baby. This is the year of the 150th anniversary of the 14th Amendment, at least of its passage. Some of us in this business experienced, all of us in this business, the Civil War sesquicentennial. We thought that was pretty well over last spring, all the commemorations, all the conferences, all the symposia. Eric and I lost count of the number we were at together, and we thought it was all over, and then, of course, the mass murder in Charleston happened, and nothing was over. Now, what we don't want to happen is that it takes something like that again to get Americans thinking about the anniversaries of Reconstruction. With Reconstruction, we're going to have to force it because most Americans don't think about Reconstruction or, for that matter, even know anything about it, which we're constantly reminded about in this presidential campaign. Why do we have law? Why on earth do we even have government? Why do we have this deep, abiding, eternal problem of federalism and states' rights? Why do we have this deep, abiding, and probably eternal problem of race? Both of those huge, huge American dilemmas pass right through this story of how we got 3 constitutional amendments and the reimagination of the U.S. Constitution out of our Civil War. John Bingham, who wrote Section 1 of the 14th Amendment, and I'm not a triumphalist about American history. The few of you here who have me in a course know that. But sometimes I get a little triumphalist about John Bingham. Sorry?
We're just chatting about something.
Oh, okay. Akhil's saying I shouldn't be, right? No, I shouldn't be, I know. But I spent hours once in an archive reading his speeches during the debates over the 14th Amendment, and he just captured me. I don't know why. I'll leave it then. I won't bring up John Bingham again if I can help it.
Great. Read Thaddeus Stevens too.
Well, I did. I read them both. I read them both, and I read the reactions. But what Bingham was after in those 2 simple sentences of Section 1, as he said over and over and over in speeches, was to, as he put it, federalize the Bill of Rights. He wanted to make it possible that the Bill of Rights could be enforced by the federal government in the states, as he says, over and over and over. Now, there's a lot more to the 14th Amendment than simply that proposition, and we will come back to all of this. The 14th Amendment was passed after long debates through the winter of '66, came out of the Joint Committee on Reconstruction in January and February of 1866. It followed after the first Civil Rights Act. The Civil Rights Act of 1866 passed in April, about 150 years ago next week. It was passed on, the 14th Amendment was passed on June 8th, 1866, 38 to 11 in the U.S. Senate, and 138 to 36 in the House of Representatives. It wasn't ratified, of course, for 2 more years until July 1868. After the end of the impeachment crisis and trial of Andrew Johnson, just as the 1868 election was revving up, but still with the ex-Confederate states out of the Union, which is, of course, always been one of the legacies of this story, that it was done, the great amendments of Reconstruction were done with the 11 Confederate states out of the Union. Although by the 15th, Tennessee was
Oh,
back.
in the 15th, they were all back in.
The 15th, they're all
Except 3.
Yeah.
at ratification.
Yeah, well, right,
Okay. Well, this is what's going to happen now. But in a moment, I'm going to shut up. What I've asked our panel to do is, I first started out on email saying that these got 3 minutes to just declare their own sense from their own tradition, their own work of the most significant, powerful legacy or meaning of the 14th Amendment. I began to get a little pushback and requests for 4 minutes, 5. So I loosened up a little. We may go to 4 or 5. And they're all going to take a little different take, which makes perfect sense. Let me introduce this group as quickly as I can. This could go on all day, and I don't want to do that. Akhil Amar is Sterling Professor of Law and Political Science here at Yale. He's educated here at Yale throughout. He clerked for appeals court judges. He's been cited numerous times. I think it says here 30 different cases out of the Supreme Court. He's been an advisor to the TV show West Wing, Colbert Report, on and on and on it goes, Charlie Rose, etc. But most important, he's written numerous books, and there's another one yet to come out that I don't even know about yet. Books like The Constitution and Criminal Procedure, First Principles, the book, The Bill of Rights, Creation and Reconstruction, and the big book that hopefully most of you are familiar with at least, The American Constitution, A Biography. That book is so important, and he has to hand it out so often. We park in the same parking lot, and we often park right next to each other. And he opened his trunk one day, and the trunk was full of copies of that book. And I thought...
Because no one buys them.
No, I figured just you get so many requests that you gotta have it, you gotta have a supply. You know, I hadn't thought of it, I never thought of that. My trunk has a lawn chair in it. I mean, anyway, and there is a new book. Is this the newest book? The one called The Law of the Land, A Grand Tour of Our Constitutional Republic. That's the new book coming out. Okay, great. Tomiko Brown-Nagin teaches at the Harvard Law School, but she's also a trained historian. She did her BA, as I learned last week. I gave a lecture at Furman University last week in Greenville, and we're just having a chat at dinner, and I suddenly mentioned, somebody asked me what's going on up here, and I said I was doing this panel and mentioned who was on it. And God, 20 minutes later, her former teachers were still raving about Tomiko. Graduate of Furman, PhD in history at Duke, Yale Law School, has clerked for 2 different federal judges, U.S. Court of Appeals, U.S. District Court. She's the author of and won the Bancroft Prize. In fact, we got a bunch of Bancroft Prize winners here. In 2011, her book, Courage to Dissent, Atlanta and the Long History of the Civil Rights Movement, is what won the Bancroft. She's now at work on a biography of Constance Baker Motley, the civil rights lawyer, politician, and judge of great civil rights fame.
And a native of New Haven.
A native of New Haven, that's right, that's
Yeah.
right, that's right. Are there lots of sources here? Talk about that later. Eric Foner. You know what, I've introduced Eric at Yale so many times. Why don't you all just remember what I said last time? I'm kidding.
That's all right.
I grew up reading this man's work, seriously. And from Free Soil, Free Labor, Free Men, actually from the Tom Paine book, through Free Soil, Free Labor, Free Men, to the Great Reconstruction Synthesis, the shortened version of which I teach in my class, and some of the people out here right now probably already have it in their backpacks, to his latest book on the Underground Railroad, to the great book on Lincoln and slavery. Eric has kind of set a standard in our profession for how you do this and how you write about particularly the period of the Civil War and Reconstruction. He's been the president of every association we have, the AHA, the OEH, the Society of American Historians, and probably 2 or 3 others I can't remember. He's also the author of a major and best-selling textbook, Give Me Liberty. I don't like that book because it knocked ours out of the top 5 or 6 in the first year out, I think. But anyway, Eric Foner.
Thank you.
Yeah. So remember that the next time I have Eric up here, would you? Okay. And Amy Drew Stanley from the University of Chicago. Did her PhD here at Yale. with David Bryan Davis, I believe, like a lot of other people. She is a historian of the entire 19th century. She's written about everything from the early republic to all the way up to the progressive era. Her interests are especially capitalism, slavery, emancipation, and I love the way she puts it in her bio, the historical experience of moral problems. We ought to. Well, yeah, how could you study with David Bryan Davis and not be thinking about moral problems? Who did it any better? She's the author of From Slave Emancipation to the Commerce Power, An American History of Human Rights. Oops, I'm sorry, that's the forthcoming book. That's the one she's currently writing now, A New History of Human Rights. Her important book earlier is the book From Bondage to Contract, Wage Labor, Marriage, and the Market in the Age of Slave Emancipation. She's written all kinds of articles on all kinds of issues, especially emancipation, human rights, and the age of Reconstruction. And last, John Witt, our colleague here in the Yale Law School. John is the complete product of Yale, BA, history PhD, Yale Law. He went down south to the minor leagues at Columbia for a while, and but came home. They get farmed out to New York once in a while. He's the author of many books, Bancroft winner for the book Lincoln's Code, The Laws of War in American History. Many other books, including Patriots and Cosmopolitans, Hidden Histories of American Law, and a book called The Accidental Republic, Crippled Working Men, Destitute Widows, and the Remaking of American Law. And he's now at work, I didn't know this till I read this, although you probably told me, on a history of the Garland Fund, which was the foundation that financed all the efforts that culminated in the Brown v. Board decision of the 1950s. He's also editing a casebook on torts. I guess you are a lawyer after all. I didn't realize that. At any rate, that's our distinguished, amazing panel. And we're going to go in the order of Eric, Akhil, John, Amy, and Tomiko. There's a chronological order to that. And it was wonderful because I started asking them, so on email, what are you going to talk about in your 3 minutes? And they started responding, and they all kind of fell out responding to each other, and it took a natural form, of course. It had nothing to do with what I asked. So, Professor Foner.
Thank you, David. I had a call from a reporter today who was writing something about the 14th Amendment, this happens frequently, and wanted to know, under the 14th Amendment, I'm glad Akhil is here to answer this, are babies born on American aircraft, airplanes, birthright citizens? I said, how many such cases are there, actually? And it turns out that there was one, and it hasn't been adjudicated yet, but apparently if a baby born on a ship, even an American ship, if it's in international waters, doesn't count as birthright citizenship. I leave this to Akhil to figure out. That does not take up part of my 3 minutes.
Who's the lawyer here?
All right. What was the 14th Amendment? The 14th Amendment was an effort to settle big questions that arose out of the Civil War. It is the longest amendment, I believe, to the Constitution. And looking at it, you'll see it brings together, it touches on all sorts of issues, the national debt, the Confederate debt, the Southern representation in Congress, the treatment of Confederate leaders, the relationship between the federal government and the states, all sorts of things that pushed in. And basically, the Republican majority, or supermajority really, in Congress at this point, wanted to constitutionalize their concept of what the Civil War had accomplished. It was also meant to constitutionalize the Civil Rights Act, which had just been passed over the veto of President Johnson. But the first clause, the section, which is what we're all interested in nowadays, but as a general principle, the Civil Rights Act had listed specific rights that African Americans were to enjoy the same as white people. They used that language. Same way white people enjoy these rights, everyone else has to enjoy them also. But Bingham put into the Section 1 of the 14th Amendment the general principle of equal protection, not listing specific rights, because he realized you might leave some things out if that could be important if you listed specifically. In fact, if you go back to the Congressional Globe, there's not a lot of debate about the first section of the 14th Amendment. Most of the debate in Congress is about the third section, penalizing in one way or another Confederate leaders. The reason is it had all been debated when the Civil Rights Act was up, so you have to go back to that debate to see what they had in mind. The 14th Amendment was a series of compromises. There are those, dead and alive, who insist that we have to always look at the original intent of the Constitution. But there is no single original intent here. This was hammered out between different factions of the Republican Party, and for many, many motives, like any other act of Congress, partisan, political, idealistic. They wanted to make sure that the Republican Party remained in power. But they also wanted to put into the Constitution a new definition of American nationality, American citizenship, a definition which was new in the Constitution, but which had actually been discussed at length by anti-slavery people before the Civil War. These ideas, the idea of a nation of equals, legal equals, beyond the tyranny of race, have been bandied about for many, many years by anti-slavery people, including Bingham. It had not been put into the Constitution. It had not been accepted by the courts particularly, but it was out there, and now they had the ability to do that. Another point I want to emphasize is Reconstruction was a dynamic process. This was a resting place. It was not a final thing. You have to view the whole period as an ongoing process of experimentation. The 14th Amendment dealt with some things. It did not deal with others that they had to come to deal with later on, particularly the question of black suffrage. So now I will just finish up by saying even though we're near the law school here, we are too caught up in the whole question of how the Supreme Court interprets the 14th Amendment. As a historian, I have no interest in what 9 or 8 uneducated people, or people uneducated about American history, think about the 14th Amendment, any more than 8 or 9 people out on the street. What they, as a citizen, is very important to me, their interpretations, but it doesn't really tell us very much about the history of the 14th Amendment. In fact, the Supreme Court has, because the 14th Amendment is a series of compromises, it can be interpreted in many ways, but over the years, the Supreme Court has consistently chosen the most conservative way of interpreting the 14th Amendment. But when it comes to race, they're very open on other issues. Gay marriage, we just saw. The invented idea of corporate personhood, which was put into the 14th Amendment by them, even though it was not intended to be there. As a historian, what strikes me is the residue of the Dunning School is still embedded in our Supreme Court jurisprudence in very bad decisions over the decades on the 14th Amendment. And I'm waiting for the Supreme Court to just reject all of those previous decisions and say, all right, we blew it, folks. We've read Professor Foner's book finally, and we're going to change how we think about the 14th Amendment. Okay, that's my opening remarks.
Thank you. Say what you think. Akhil, what's it all about?
So such an honor to be with you all and on this extraordinary panel. So let's look at the text. At least 4 ideas in the 14th Amendment. First sentence has the idea of equal birthright citizenship. Everyone born in America, probably even in American airspace, is a citizen of the United States by dint of birth. We're all born citizens, and we're all born equal citizens. We're all created equal. There's an implicit equality idea there because if we're all citizens and we have the same status. So it's a codification of Lincoln's reinterpretation of Jefferson. It doesn't say race. The 15th Amendment's going to say race, color, or previous condition of servitude. It could have said race. We're born equal. It is about racial equality, whether we're born black or white. but we're also born equal whether we're born male or female, Jew or Gentile, gay or straight, whether we're born first in the family or fifth, no primogeniture and entail laws, whether we're born in wedlock or out of wedlock. It's an extraordinary idea. Equal birthright citizenship, Mr. Trump. Whether our parents were citizens when we were born, as might be true for some of you up here, or whether they were not citizens at the time you were born, as is true of me. I was born in Ann Arbor, Michigan. Equal birthright citizenship, Mr. Trump. And that it's not limited just to states. It doesn't say no state shall. That's a norm that applies even against the federal government, an equality norm. It's a norm that informs even our private relations as citizens. Congress is going to have the power to enforce this equal birthright citizenship idea. So that's one idea. Second sentence, states have to follow fundamental rights. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. At its core, that's going to be, if you just think about what are your privileges and immunities as a citizen? Well, stuff in the Bill of Rights: speech, press, petition, assembly, free exercise of religion, right to be free from unreasonable searches and seizures, and other fundamental stuff too. Privacy. So where do we find these fundamental rights? Because if they just meant the Bill of Rights, they could have said something a little more explicit. Well, we find them in the American tradition, in the Declaration of Independence, in state constitutions, in our traditions as a people, in other parts of the U.S. Constitution. The habeas corpus clause isn't in the First Amendment. No state gets to mess with these fundamental rights. The original Bill of Rights, drafted by the framers, limited only the federal government. Say that again, it limited only the federal government. Congress shall make no law of a certain sort. And there was the 10th Amendment, and the original Bill of Rights is about local militias and local juries. Now think, just for a second, about what are the most important cases that you think about as Bill of Rights cases. And they're strictly speaking not Bill of Rights cases. They're 14th Amendment cases that involves a state. Mapp versus Ohio, Gideon versus Wainwright is Florida, Miranda versus Arizona, Roe versus Wade is Texas, New York Times versus Sullivan is Alabama, Obergefell is Ohio. Tinker versus Des Moines is Iowa, Lawrence versus Texas. The cases that you call Bill of Rights cases are actually incorporation cases. The Bill of Rights is incorporated against the states. Fundamental rights now will be enforced by the federal government against the states. So that's the second idea. Free labor is one of those too, even though it's not in the Bill of Rights as such. Third idea, what about, these are called civil rights, and even sometimes aliens have them. There's actually reference to rights of persons as alongside citizens, because due process is a privilege or immunity. So why do they say due process again a second time? Because they believe, Mr. Trump, that persons, even who weren't citizens, had constitutional rights. Dred Scott said, no one who's black can be a citizen. They said, yes, you can be a citizen. That's the first sentence. And Dred Scott also said, only citizens have constitutional rights. They said, no, people who aren't citizens also have constitutional rights to due process. Okay. But it wasn't quite about voting rights, political rights. Section 2 indirectly protects voting rights in a certain way. It talks, for the first time, the words the right to vote appear in the Constitution, but Section 2 doesn't directly guarantee that. It just says if certain folks are disfranchised, the state gets fewer seats in the House of Representatives in the Electoral College. It's an indirect way of incentivizing a right to vote that's going to get added. That's the first time the phrase the right to vote gets added to the Constitution, and there are going to be more additions. It's also the first time the word male gets put in, and maybe we're going to talk about that. Equal birthright citizenship, fundamental rights that states have to abide by, indirect protection of political rights in Section 2, and broad sweeping federal power. 14th Amendment ends, Congress shall have power, so does the 13th Amendment, Section 2, and with similar language. And the 15th Amendment, the original Bill of Rights begins with the words, Congress shall make no law of a certain sort. It's a limit on the federal government, and now, reflecting the American Revolution in which the central government is suspect, but now after the Civil War, we believe in federal power and states have misbehaved, and Congress has power to enforce these amendments. Finally, I want to endorse this idea. It's a process. It's an unfolding. It's experimentation. Just in a nutshell, I know John is going to probably take us back to the Civil War. So The founders created a pro-slavery regime in which slavery is built into the electoral college. You get extra votes in Virginia, extra electoral votes, because you got slaves, and all your early presidents pretty much are Southerners or Northern men of Southern sympathies. There's not a single openly, avowedly anti-slavery president as such until Lincoln, and he wins despite the electoral college, not because of it. And all the South has to do is do nothing at all, and they'll win because Lincoln doesn't have a majority in House or Senate. All they have to do is wait him out, Mitch McConnell style, but they're too stupid to do that because they don't know how to do democracy, so they take up arms against a duly elected government, and only then we're going to see this revolution that happens. Because originally Lincoln is saying, if you come back in, I'll endorse the 13th Amendment that says slavery forever in the Constitution, unless a state voluntarily wants to get rid of it. That's the original 13th Amendment he's willing to sign off on. And then he says, come on back in, the Union as it was. That's the original war vision. But these guys are not just stupid, they're fierce. They fight really hard. Because they end up fighting so hard, he has to emancipate slaves in order to win the war and keep Britain out of the war. So now the war becomes not just a war for union, but a war to end slavery. And once they fought nobly, and they're the margin of victory, he has to be faithful to them. So his party in 1864 says, we're for ending slavery. They weren't in 1860, but in 1864, the war aim has evolved. It was a war for union, now it's a war for freedom. And now he says, we have to have an amendment codifying this, and here's one of the reasons why. Because the remnants of this conservative regime, the Roberts Court, the Taney Court, are still in place, and if I don't bulletproof the Emancipation Proclamation, the Supreme Court is going to strike down Obamacare. Strike down the Emancipation Proclamation. So we got to put an amendment in because conservatism is still very strong. Conservatism is still quite strong in America. So the 13th Amendment is pushed because you got to deal with the Supreme Court, and he gets it. He wins re-election, and he pushes it through the lame duck, Spielberg in that movie, and then you think, okay, done. Wow, that's amazing. That's a revolution. And then there's this moment, I refer to it as the oh crap moment, when they realize they can't stop with the 13th Amendment, because here's the problem. 3/5 has now become 5/5, because we got rid of slavery now, and if the South comes back in, they're going to have more seats than ever before in the House and the Electoral College, and they're still not letting black people vote. So we're going to need a 14th Amendment to deal with that, and once we're going to need to do that by a constitutional amendment, we need to fix some other things too, and we do. And as a condition of re-entry, they eventually insist that the South let black people vote. And now, because they're not ready in the 14th to say everyone has to vote equally. But once black people have to vote in the South as a condition for re-entry, now we can do a 15th Amendment to extend that idea to the North. So it is an unfolding process, and they don't think about everything right at one moment, and one thing leads to another, leads to another.
Akhil, that was better than when I heard you on NPR.
But I think I went over. My
That's
apologies.
quite all right. We'll come back to lots of those issues. Thank you. Applause, sure, why not? Well, now, John, sorry.
It's never a good idea to be the person following the brilliant Akhil Amar. The only silver lining for me here is that as Akhil suggests, his comments end in some ways where I would begin. So here, in my quickly dwindling 3 minutes,
4 or 5.
two thoughts on how we might think about the 14th Amendment. Two thoughts that I think might depart in interesting ways from the really important observations that both Eric and Akhil have started with. So let's think about the 14th Amendment as the end, maybe the premature end of one story, and as the beginning of another story that's still unfolding now. So the end of a story, what do I mean? So in the beginning of 1866 through to ratification in 1868, one thing that the United States is struggling with is the foundation of federal power in the Reconstruction South and more generally. And the great question is, what does the war power still authorize? What does the war power still authorize? Now, the war power, since John Quincy Adams in the 1830s, had been seen as one of the great writs, one of the great warrants for federal power to abolish slavery. Of course, Lincoln took Quincy Adams up on this in the Emancipation Proclamation, citing it as an act of justice and an act of military necessity, invoking a just war tradition that authorized states to pursue justice, even if it meant war, even if it meant war. In the wake of the war, the Congress is using that war power, and it is articulated by people like Charles Sumner or Thaddeus Stevens as the central way in which the federal government can protect the free people in the American South. But in the beginning of 1866, that war power is at risk. So on April 2nd, 1866, Andrew Johnson says the war's over, The next day, the US Supreme Court announces its decision, although doesn't give us an opinion, in a case called Milligan, which is undoing the power of the federal government to use military commissions to bring justice on the ground in the Reconstruction South. And across 1866, the question of whether the federal government has the power to do things like create a Freedmen's Bureau is up in the air. Now, how does this play into the 14th Amendment? What the 14th Amendment is doing is, of course, creating a basis for ongoing federal power, and that's an important part of the story. But it's also creating the end of a particular story, the end of the just war story, in which a huge amount of power is given to the federal government to bring justice, to bring the kind of justice that emancipation brought to the South. And it's replaced by a 14th Amendment power which is considerably more limited and is limited and hedged in a variety of ways. So if we think about it this way, it is certainly true, as Eric and Akhil have rightly brought our attention to, that the 14th Amendment includes powerful ideas which animate our politics to today, but it also brought an end to the power that had brought justice through the Civil War, as Akhil rightly says. Now, the regime it puts in place is, I think, rightly described as a regime. So when I look at the text that you have in front of you, what I see is, in some sense, a mini constitution of its own. So it's got a section 2, which more or less sets the boundaries of the electorate. It's got a section 3 that says certain guys can't be in this new government. And it's got a section 4 and a section 1 that rules certain things for the ongoing regime out of bounds. So we have a new constitution, in some sense, put in place, which, as Akhil says, through incorporation, will become the constitution that we're so familiar with today. So the end of a story, and because of the end of the story, a kind of ambiguity to it, that is not just delivering ideas about justice, but in some ways cutting off our access to certain ways of advancing the project of justice, and at the same time putting in place ideals that we're still grappling with today in the US Supreme Court, but not just in the US Supreme Court, in the Black Lives Matter movement and elsewhere. So hopefully that's a useful beginning and end, and with that I'll turn it over.
Thank you.
Sure.
It works.
So I don't want to talk so much about the 14th Amendment and the text of the amendment. I want to talk about what Congress tried to do with the 14th Amendment. And this takes off directly from what John was saying. And it's about the question of power and Congress's attempt to use this newfound power to enact human rights. So today I'd like to argue that slave emancipation gave rise to a new conception of free personhood, that all human beings possess a fundamental right to seek amusement and to experience rapture in public by virtue simply of being human, not property, not things, not slaves. My argument involves 3 points. First, that Congress set forth this guarantee in the Civil Rights Act of 1875. Second, that Congress drew on its newfound power under the 14th Amendment in tandem with the 13th Amendment to enact this guarantee. In the era of Reconstruction, the sovereignty of the American nation-state became tethered to a new birth of a right to be an amusement seeker as embodied in the 1875 Civil Rights Act. Third, that the entitlement of amusement seeking transformed the human rights tradition inherited from the Age of Revolution, which was rooted in proprietorship and wealth accumulation. Therefore, I argue, this anti-slavery entitlement transformed understandings of humanity itself. Let's begin with the words of an ex-slave who became a congressman from Mississippi. His name was John Roy Lynch, and he'd once labored as a slave in the cotton fields. Speaking of the 1875 Civil Rights Act in Congress, John Roy Lynch put it simply, quote, "This bill has for its object the protection of human rights," end quote. So now let's turn to the text of the 1875 Civil Rights Act. It was the final decree in the congressional destruction of slavery. It was meant to eliminate the last vestiges of slavery. Consider the language of the act, and I'm going to read the statute. Well, the first part of it, quote, "All persons within the jurisdiction of the United States shall be entitled to the full and equal enjoyment of the accommodations, advantages, facilities, and privileges of inns, public conveyances on land or water, theaters, and other places of public amusement." Theaters? Public amusement? So by no means was this an ascetic article of freedom. According to the act, the negation of slavery entailed pleasurable liberties, the right to be an amusement seeker, and still more peculiarly and particularly, the right to be a theater goer. Right? So that's odd, right? It's odd. So we have to explain this language in the statute of the last enactment of Congress of slave emancipation, theater goers and amusement seekers. This was an idea of freedom nowhere to be found in prior declarations of the rights of man and citizen, not in America, not in France, not in Haiti. Famously, the United States Supreme Court struck down the 1875 Civil Rights Act as an unconstitutional intrusion of congressional power into private affairs, thereby reining in the emancipatory reach of the 14th Amendment. The court rejected the theory that a Jim Crow theater, though licensed by government, involved state action, or a denial of equal protection, or a deprivation of liberty without due process. So, as Eric said, forget what the Supreme Court says. We need to understand what the impulse behind the legislation was, what Congress was trying to do, what it meant. My argument is that the aborted 1875 Civil Rights Act marked a turning point in the death of slavery and the emergence of human rights. The legislation spoke in universalist terms of all persons, not just of citizens. The freedoms it enumerated did not simply echo older declarations of natural rights. Rather, the 1875 Act enshrined the idea that intrinsic in a person was a right to pursue pleasure in association with others, and that this right must be encoded in the positive law of the nation-state. Newly, the status of not being a slave, a thing, property, but rather a human being extended beyond equal liberties of work, of contract, and of property ownership. The rights bearer was not a mere homo economicus, not a mere possessive individual. From the revolution of slave emancipation emerged the idea of a sensuous and a sociable entitlement protected by the nation-state for the purchase price of a ticket. Here was something new in the history of human rights, a guarantee of non-acquisitive happiness as the negation of chattel slavery. So evidence, listen to the words of those who sought the passage of the 1875 Act, the meaning that they ascribed to it at the time. Consider an appeal uttered by a freeborn black man who had once been an operator of the Underground Railroad and who had led colored troops during the Civil War. He spoke of viewing The Merchant of Venice, attesting to, quote, rights and feelings that distinguished him from a brute in appreciating works of art. Quote, "I feel keenly," he said, quote, "Shylock's words depict the feelings that animate with great intensity the colored man. I'm not demanding a pound of human flesh, but I am demanding exact justice as denominated in the bond between me and my government," end quote. Listen to a letter from a Virginia ex-slave to Senator Charles Sumner. He wrote, quote, "Look at the white man and the black man. They both have one bone, one blood. If I pay my money at a place of public entertainment, it is as good as if a white man had paid his at the same place. All that are sacred will be found in one heaven, end quote. Consider the argument of Senator Charles Sumner, the author of the 1875 Act, justifying the authority of Congress to enact the law under the Reconstruction amendments. Quote, "The Constitution is overrunning with power. It must be interpreted to advance human rights." And then Sumner went on, quote, "The slave is free, no longer a chattel. He longs, perhaps, for respite and relaxation at some place of amusement," end quote. Thus, Congress must protect this pursuit of amusement as an inviolate right of freedom. And listen to the eulogy that Frederick Douglass delivered on the 1875 Act when it was nullified by the Supreme Court in 1883. Douglass said, quote, "Oh, for a Supreme Court which shall be as true, as vigilant, as active in maintaining law enacted for the protection of human rights as in other days was the court for the destruction of human rights," end quote. And a coda. A century after the Civil War, the entitlement to amusement seeking was resurrected in the Civil Rights Act of 1964, and the Supreme Court upheld the 1964 Civil Rights Act. But under the Commerce Clause, not the 14th Amendment. Paradoxically, as America celebrated the centennial of slave emancipation, human rights, the right to seek an amusement, the right to go to a theater, newly came to amusement seekers by virtue of the free flow of commodities rather than equal protection of the rights of persons. So my final point. Over time, the commerce power of Congress has extended precisely where the reach of the 14th Amendment and the 13th Amendment end.
Thank you. And Tomiko,
Yes.
take us to the 20th century.
Well, going last, I'm not in a very good position, am I? Following these scholars and being in the position of repeating some of the points that have been made, hopefully in a slightly different way. The first thing that I would say about Reconstruction is to actually bring us to W.B. Du Bois, who said that Reconstruction was Black America's brief moment in the sun, which is such an elegant way of explaining the promise of Reconstruction. It's brief and incomplete, not because of any problems in the text of the Reconstruction Amendment or in the legislation that was enacted by Congress. It's brief and incomplete because of continuing resistance at the state level and by private actors to the Reconstruction Congress's constitutional vision, by the people on the ground as well as by the U.S. Supreme Court, that really undermined that vision because it couldn't accept the full implications of what the Reconstruction Congress had done. And so if I had to point to a theme to emphasize about Reconstruction, it would be a cycle of intervention followed by neglect and even at point hostility to the enforcement of the Reconstruction Amendment. And again, the U.S. Supreme Court is deeply implicated in that cycle, that swinging back and forth. So for a first point, I want to restate some of the things that Akhil said and Eric said in a different way. And that is the primary achievement of Reconstruction is federal supremacy. It is a revolution in the political structure of this country, with federal authority promised to displace state power when state power burdens people who had been emancipated, okay? So it's federal supremacy in Section 1, backed up by Section 5 of the 14th Amendment, which gives Congress the power to enforce the amendment through appropriate legislation. Now, the second point that I would make is just to reiterate how the U.S. Supreme Court, in interpreting the Reconstruction Amendments, did its very best to undermine a broad interpretation of the abstract language that is a part of the 14th Amendment and some of the legislation that others have already talked about. Now, to speak about the Supreme Court as undermining individual rights and that restructuring of political political structure might seem a little odd in the wake of cases like Brown versus Board of Education or the gay rights case that the Supreme Court just decided, which led to the understanding that the Supreme Court would actually enforce, would be the primary body to enforce individual rights. But that is not, in fact, what happened. So you have cases like the slaughterhouse cases, which nullified the P&I clause. You have the civil rights cases, which made clear that only state action could support a constitutional violation. It's a nice idea, a logical idea, but when you think about the facts on the ground, how in a society that was imbued with white supremacy, lots of different people were implicated in undermining freedmen's rights, and so the impulse there makes sense, but in the final analysis, the Supreme Court is deeply involved in restricting the interpretation of the Reconstruction Amendments. I want to go back to the point about Section 5. Section 5 of the 14th Amendment makes Reconstruction an ongoing project, allowing Congress to respond to problems of inequality, not only of race, but of gender, all sorts of discriminations, disability, and so forth. And over time, pursuant to Section 5 authority, Congress has enacted a whole range of legislation that makes Reconstruction a project that has been live and important for all of us. So the Fair Housing Act, Section 1983, the Family and Medical Leave Act, the Violence Against Women Act, all sorts of laws that not only implicate racial inequality, not only implicate the original meaning, if we want to go to that point, of Reconstruction, but all Americans, bringing all Americans into the Reconstruction project. Now, I said I was going to talk about the second Reconstruction, so let me do that a bit by saying that the second Reconstruction during the era of the 1960s is a do-over. A do-over. Successful in part because new voices are a part of the discussion of the meaning of the Constitution. I'm talking about the social movement actors. Dr. King, who has the ear of President Johnson. They're all a part, all of these actors are part of the context in which Congress enacts the Omnibus Civil Rights Act of 1964, which is a do-over of the 1875 Civil Rights Act. And I'd underscore the point that Professor Stanley made about how in some ways odd it is that the Supreme Court ends up upholding that act under the Commerce Clause. Odd, but at the same time you can understand that the anti-discrimination norms of Reconstruction also are part of the logic of the Supreme Court upholding that Civil Rights Act. And so in the final analysis, the Reconstruction history, the Reconstruction legislation, the Reconstruction vision lives on, it gains new life during that era, even if at the Supreme Court it's understood in terms of the Commerce Clause. Of course, as Eric said, they don't know what they're doing, they don't know history, but however they reach the desired end, we're willing to take it.
Well, thank you, all five of you. This is amazing. There are 1,000 ideas in the air here. I'm going to pummel them with a question or two, or propose a question or two, and then we're going to open it to Q&A. Do we have mics down the rows? We do. Okay, good. All right, everyone on the panel, anyone pick this up? We've talked about process, limitations. We've talked about the end of one kind of power, the beginning of another kind of, end of one regime, beginning of another. We've talked a great deal here about great rise of the shining moment, the shining in the sun moment, the great rise and seemingly rapid fall. Why couldn't the 14th Amendment hold these great ideas that Eric and Akhil laid out so eloquently? What was it about that? I mean, within 10, 15 years of its passage, it's being eroded, or, as Amy pointed out, by 1883, the civil rights cases of 1883, it's being all but, not obliterated, but close to it. And how could that happen by this ignorant Supreme Court that was appointed by, all of them appointed by Republicans?
Right, they were all Republicans.
How did that, I mean, for Americans who are not nerds on this, which is most human beings, and even those of us, some of us who are nerds on this, we're still wondering, how could this great revolution rise so fast and then fall so fast?
Well, that's.
I know, you wrote 812 pages
I know, you
about
want to
that.
read the whole book and then you can find out. But, no,
He's always saying, just read my book. Did you know?
no, I mean, I think that's a perfectly.
But the rest of us are saying that too.
No,
about his
that's a
book,
great
so.
question, but you know, even, as I said, even the 14th Amendment itself has weaknesses within it.
Compromise.
It is not, it's compromised, it is not what the radical Republicans wanted, nor was the 15th Amendment written in the way the radical Republicans wanted. The Binghams and the Stevenses were not necessarily the determining factors there, and the very fact that you have a new regime, the old concepts, whether it's racism or localism, federalism, were still very much alive as they are today. Do you think the 14th Amendment could be ratified today?
No.
No. So it's not.
Not in the 36 Republican-controlled
Right,
legislatures.
so, you know, this was a crisis moment. It is possible to do, it is possible to do things in a revolutionary crisis, whether it's the end of the crisis or not, as John said, that in normal times are almost impossible to do. And I think as normality came back in some ways, the older attitudes began to reassert themselves pretty quickly. And you don't do, as somebody said, Amy or Tomiko, the slaughterhouses, 1873. I mean, that's during the middle of Reconstruction. The court is already chipping away rather strongly at what the 14th Amendment is all about. So, you could turn it around and say, how did they ever manage to get this thing passed?
Yeah.
That could be the remarkable thing, rather than the fact that it couldn't really be implemented fully over a long period of time.
Helps to have 11 states not voting who had just
But,
fought
let me just say
Civil War.
one other thing, and then I'll shut up. What John said, I want to add one point to what John Witt said, which is to say the end of the just war. You could see the 14th Amendment almost as a proposed peace treaty. This is the end of the Civil War. Here's what the Civil War, and they did say, if the southern states ratify, they're back in. And Tennessee did ratify
Yeah,
and has
Tennessee did.
got its representation back. The rest of the southern states, just as stupid after the war as before, said, no, forget that. No, they'll never do anything more, so we're going to repudiate, we're going to refuse to ratify. But in a sense, it's a proposed peace treaty to end the war and have a post-war regime. But that's not how it works out, because the South refuses to accept it, and you have to then go further.
But with a peace treaty with some very bitter pills for the losers.
Well, they lost,
No,
that's
that's
true.
true. The moral is, don't lose a civil
Right,
war. I mean,
right.
not a good idea.
But they also don't stop fighting. I mean, so
Right.
this is part of the problem with the end of the war power. So
Right.
one answer to David's question would be that the 14th Amendment contains within itself, in its move away from the war footing, the seeds of the story you're telling. Because in Nathan Bedford Forrest is creating the Klan just as the beginning of the 14th Amendment process is underway. In South Carolina in 1870, there's going to be all-out warfare. In the Colfax Massacre of 1873, the same. And the power that the 14th Amendment leaves the federal government is not a power that can deal with this continued warfare in the same way.
Well, I would just cite federalism, inasmuch as I said that the great legacy of Reconstruction is federal supremacy. Of course, that's open to debate, including because of the Supreme Court's tremendous role in saying what the Reconstruction amendments mean. So I mentioned slaughterhouse. There's language in that decision about the implications of the most robust interpretation of the P&I clause, with it being said that, what is really being asked here is for the federal government to be a perpetual censor on state legislation, and that just cannot be. And if you think about all of the moments when the Reconstruction project have seen a decline, whether it's in Section 5 or even in the context of school desegregation, it's all about states' rights. That was a pushback against the Civil Rights Act in 1964. What are you doing to the states? How can you take away state power? So that's federalism in a word, is what I would say.
And it's at the basis of voter suppression today,
Yes.
state control.
So if we take the story once again back a little bit earlier, I think the real question is the inverse. How did something so radical ever even happen for a brief, shining moment? So America's Constitution is built on slavery. The Electoral College is designed to give the South basically a big inside advantage for the presidency because they get to count slaves, albeit at a 3/5 discount. 32 of the first 36 years, it's a white slave-holding Virginian in power. Pennsylvania has more free people than Virginia in 1800, way more voters than Virginia, and fewer electoral votes. You take away the extra electoral votes that Thomas Jefferson gets from slavery in 1800, John Adams wins that election. And John Adams and John Quincy Adams, even if they don't love slavery, their running mates are South Carolinians. You can't, John C. Calhoun is the vice president for John Quincy Adams. The states that get rid of slavery, even states that didn't have very much slavery, got rid of it very slowly. It takes Connecticut 50 years, New Jersey 50 years, because their entire way of life depended on foreign oil. Depended on slavery, and they couldn't easily transition away from it. Their economy did, and the North is complicit in this with shipping and insurance and banking. See Edward Baptist, The Half Has Never Been Told. Everyone's profiting from it. It's the engine that drives America. So Abraham Lincoln says, 1858, it's going to take us 100 years at the least to actually put us on, because Lincoln proposes putting slavery on a path of gradual abolition. Now, instead, what happens is you have, because of the war, which you would never have before, immediate, universal, uncompensated Russian Revolution, avant la lettre style revolution of a sort that you never had before. That's a massive wealth transfer, epic Russian Revolution style, but not followed up with a massive additional 40 acres and a mule is never quite redeemed. The economic backbone of the plantationocracy isn't broken. There isn't, and so they promise eventually sort of voting rights, and there's massive pushback, and you can understand why, because this is un-American, and the South feels it didn't buy into these amendments. They were jammed down its throat. They were forced at the barrel of a gun to ratify this. So there wasn't total buy-in, and so just to borrow, and the judges, they're judges and they're appointed by the Republicans, but the Republicans are becoming, the party of Lincoln will become the party of Grant, will become the party of McKinley, and increasingly corporatist, but lawyers are well-fed folk, and so we're judges, and they understand the earlier regime, and they often don't quite get legal revolutions because it renders obsolete everything that they learned as a young lawyer, so they sometimes don't fully get it, the lawyers, and there's massive pushback. So the analogy would be, okay, 9/11 happens, and we originally said, okay, we got to clear out the Taliban, so that means, okay, we got to take care of Afghanistan, I guess, and so, we try to do it quickly, and then we say, well, we really have to sort of nation build in Afghanistan, we have to have women voting, we have to create boots on the ground, we have to create a new society, we've got to turn it into Vermont, this doesn't work, we try, and after a while we say, well, we just declare victory and go home, because we're tired of it, and that's Reconstruction, and, because we can't fully occupy occupy the South for another 30 years, and we didn't quite break them all the way.
But, yeah, and Amy, I do want you to help the audience understand that civil rights case of 83, which overthrows 75, because we do get us this remarkable Civil Rights Act still as late as 1875.
I'll say that very
Go ahead.
quickly. Is
Go ahead.
that Congress drew on power in the 14th Amendment to say, right, we can enforce an idea of equality of equal rights, as well as the 13th Amendment abolishing slavery. He said, this is where we're deriving power to enact this new legislation. But the Supreme Court said, no. If you, when I teach my students, you say, so, right, because it's a private place, right, that if you go into an inn or a theater, right, that this is not state action, right, because if you look at no state shall, the Supreme Court strikes it down and say, well, states are not involved because this is a private business, even though it's open to the public. And also they argue, this report contends that this is not, to segregate, to have Jim Crow, is not a badge of slavery. But if I can answer the question in a different way about why shall we say, the backlash against the 14th Amendment, and it seems to me that, right, that there is an expansive understanding of equality, of equal personhood, and an expansive understanding of the power of the nation state in guaranteeing that. And that's where the conflict lies. But I would also say that limits of the 14th Amendment were inscribed right in its formulation. And I'm going to go back to something about the relationship between the 13th Amendment and the 14th Amendment, and go back to Charles Sumner, who I talked about before. I guess we talked about, do we like Bingham? Do we like, I like Charles Sumner. But in any event, Charles Sumner had a theory that the 13th Amendment shouldn't say slavery shall not exist, as a kind of no slavery shall exist in the soil, as a negative prohibition. Charles Sumner said in 1864 that the wording of the 13th Amendment should be, listen, all persons are equal before the law, so that no person can hold another as a slave, and that Congress shall have the power to make all laws necessary and proper. Now, if that had been the text of the 13th Amendment, you wouldn't have needed a 14th Amendment, because it said all persons are equal before the law, and no persons can hold another as a slave. But it doesn't say anything about no states. But another congressman, an anti-slavery Republican, said all persons are equal before the law. Well, are you talking about women? Would that apply to wives? If all persons are equal before the law, that would overthrow relations of marriage. That would overthrow coverture. And so they withdrew it. They said, no, we can't do that. So you have the language of the 14th Amendment, the language of the 13th Amendment that goes back to slavery nor involuntary servitude should exist. So I guess what I would say is the struggle over the expansiveness of equality existed prior to the formulation and ratification of the 14th Amendment. The struggle over the expansiveness of equality was right there. The 13th Amendment was distilled on the question of gender. That's why, as Akhil said, you get in there. In the second section of the 14th Amendment, all persons born and naturalized, very expansive. That expansiveness of Section 1 becomes the basis for claims for racial equality as gender equality. Section 2, the first time that the word male is introduced into the Constitution. But just to go very quickly, when claims to use the 14th Amendment to strike down gender discrimination failed completely in the era of Reconstruction, the companion case to Slaughterhouse's Bradwell, it's not for 100 years later, in the 1970s, that the 14th Amendment, the guarantees of equality in the 14th Amendment, are read to strike down gender inequality. And that problem exists right in the formulation of the 13th Amendment and the struggle over its wording.
I think probably time we open this up for questions. It's already 6 o'clock, so if my companions could carry the microphones around. Sorry? Questions, hands, comments, revisions? Yes, sir, in the third row.
Thank you very much for this fascinating panel.
Is that on?
Is this on?
Yeah.
I had a question about enforcement and the 14th Amendment. Professor Foner, you mentioned that there was much more debate over the third section of the 14th Amendment than the first. I'd love to hear a little bit about how much debate there was over the fifth section of the 14th Amendment and whether any of that debate has informed how the Supreme Court has really narrowed.
The fifth section?
Yes.
Well, the fifth section was also in the 13th Amendment, in virtually the same language, and the 15th. So I don't think, no, the assumption was that Congress, but, you know, the problem is it's difficult for Congress to enforce, you know, things going on in the states, right? I mean, you're always reactive, right? You know, as was said, the 14th Amendment opens the door to dealing with unanticipated developments, because it says Congress can always do it. Although actually what they did a lot of in the Reconstruction was put it in the hands of the federal courts. Let the federal courts enforce all this. But the federal courts then were much weaker in structure and, you know, and in notions of jurisprudence than they are today, and it was really outside. I think, the question, ultimately they understood enforcement has to be at the state level. The states are supposed to abide by this. I mean, something that is so obvious we may forget it. When you put an amendment into the Constitution, you assume people are going to abide by it, right? That's the law. You don't assume you're going to have massive resistance to the law. But ultimately, that's why the third section is basically meant to help create new governments in the South. Johnson, of course, had put governments in. The Republicans didn't like these governments. They were all white. They were controlled by ex-Confederates, et cetera, et cetera. They did all these terrible things. Let's kick out the leaders of those governments and maybe new ones. Now, they don't say anything about blacks. That comes a year later. Then finally, they say, well, that didn't work, so we'll give black men the right to vote, and then we'll really get good governments. But ultimately, enforcement is supposed to be at the state level. But when you get all this violence and other things, it becomes impossible after a while, although in some states it succeeds. You know, one of the funny things about Slaughterhouse, and then I'll stop, is Slaughterhouse was, among other things, an effort to uphold the Reconstruction legislature of Louisiana, right? It upheld a law which butchers were, they said, no, you know, this legislature with all these black people in it, they're passing terrible laws, and the Supreme Court said, no, they have a right to pass that law. What's the problem here? They're upholding Reconstruction, but as they're doing it, they're also limiting the Privilege and Immunity Clause in very serious ways. The problem of enforcement was very difficult. 2 years later, 3 years later, they passed these enforcement acts, giving Congress and the president the power to use federal troops, marshals, federal courts. They do actually crush the Ku Klux Klan in 1871, but then later on, more violence recurs, and it becomes harder and harder to do that.
Two complementary points to that. So there's very little sort of a bureaucratic capacity on the part of the federal government. You've got a few customs officials, you've got a few judges who don't really have, command an army. So you don't have a huge Justice Department. It's not even created until 1870. You don't have, even today, a federal election officials being able to sort of monitor every precinct. Look at Florida in 2000. So there's very little bureaucratic capacity. And not only did the southern states feel that this was jammed down their throats, so they don't have a buy-in. The Democratic Party has no buy-in either. It was jammed down its throat. This is a hyper-partisan measure. Every single member of the Conservative Party in Congress votes against Obamacare. Votes against the 14th Amendment. Both are true. Both are true. Every single member of the Conservative Party in Congress votes against this. This was hatched, the 14th Amendment, in a Republican Party caucus in a secret way. They're empowering Congress, which is congressionally controlled. They take away the pardon power in effect from the president because he's a Democrat. Every single provision of this, they give more votes to Republican governments than to Democrat-controlled governments in Section 2. It's a hyper-partisan measure, start to finish. So the South hasn't bought in, and the Democratic Party hasn't bought in, and the former white Confederacy, they have not reconciled themselves to that. So democracy works best when there's a buy-in, when the losers admit that they lost, and the anti-federalists admit that they lost, and then the next round was, together let's come up with a Bill of Rights that actually embodies some anti-federalist ideas too, a sort of compromise, and that didn't quite happen.
One illustration of Akhil's important point about lack of capacity is that every one of these civil rights pieces of legislation enacted under the 13th and 14th and 15th Amendments, including Amy's 1875 statute comes with its own federal jurisdiction provision, gives jurisdiction to the federal courts and the federal judges the power to do the work of enforcing them. But there aren't nearly enough federal judges, that it is not even close, such that in South Carolina in 1871, there are successful prosecutions of the Klan under the legislation created under the 14th Amendment. It looks like the federal government can win, but by the end of the year, there are 1,200 indicted Klans members waiting for trial. It's not even close. There's two judges, and 1,200 Klans members.
They're almost all let go?
It's not going to work. So the capacity thing is really, really huge.
So federal supremacy is asserted every time here without the capacity to actually enforce it.
Yeah, well, they don't have the bureaucratic state that comes in the 20th century with all these agencies, and even today, it's sometimes not so easy to enforce federal power in local areas.
Voting
Yeah.
today.
Obamacare.
Shelby County invalidating the pre-clearance bureaucratic system of the Voting Rights Act.
Just led to all the voter ID laws. Yes, sir.
You know, putting aside the obvious time travel and Stephen King perspective, I think remains a fascinating, unanswerable question: what impact Lincoln's assassination has on Reconstruction. From your scholarship about Lincoln's views on Reconstruction prior to his assassination, can you, and because you are also such thoughtful people, can you just speculate a little bit on what you think?
Because historians love to do that.
Could you speculate
I
a
don't
little
love
bit?
No, they don't.
No.
You
Yeah.
speculate a lot.
No, they
On
don't.
what you think,
They resist.
how trends might have been different had the assassination not taken place.
Well, Akhil, you're wearing a Lincoln tie. You might have.
Well, I can recommend both of these gentlemen answered that question in the New York Historical Society, and you can TiVo.
We did.
But here's one thing, since Jim Oakes, are you there? Okay, I think I said so. He's going to keep me on my best behavior here, but I think Jim Oakes was the person who explained to me very emphatically Lincoln is a party person.
Right.
That, he's a member of the Republican Party coalition. He's going to try, he holds the coalition together. And Johnson is not really, in his bones, a Republican Party person. So I would think that on the contrary, so I would think that Lincoln would be trying to work with everyone to come up with some sort of consensus that will prevail from Stevens and Sumner through Bingham and maybe not Edgar Cowan, but.
That's exactly right. Lincoln, you would have had Congress and Lincoln working out a plan, which probably would have looked pretty much like the Civil Rights Act. There's no, these were measures that the whole Republican Party was in favor of, as you said, the 14th Amendment, the Civil Rights Act. Lincoln is not going to go against the whole party. These were measures of the moderate Republicans, which is what Lincoln was, not radical, but moderate Republican. Then you get into the speculation, which is absurd. Well, what then would have happened? We don't know. Would the White South have accepted this if you'd had the president and the Congress both behind it? Instead of having a president who kept telling them violate this stuff, it's not really laws,
He's doing every minute.
as he's doing all that time. I don't know. And what would Lincoln have done then if violence had reared its head as it did? I don't know what Lincoln would have done. So the further you get past a few months after, then it just becomes such speculation that it's really impossible to
The
talk about.
counterfactual to ask is this if there had been land confiscation, and then there would have been fundamental reordering of power, of economic power, which would have supported a different political system and would have really created a real revolution of the social order in the South in addition to slave emancipation. But that didn't
We'll
happen.
never know.
And Reconstruction tended to last longest where there was at least some land redistributed.
Is that really true? No, it's not.
Well,
Florida, they wouldn't distribute that.
South Carolina. They had land.
Yeah, they
They
did.
had land.
But Louisiana? No, forget it. No, you got to take that back. All right.
Yeah, right here.
Yeah, thank you. So looking over Section 1 of the 14th Amendment, there seems to be a pretty conspicuous switch away from talking about citizens to talking about persons. And I was wondering if you guys could comment maybe on the purpose of that switch and the kinds of legal distinctions that they were hoping to draw between the rights we afford to citizens and the rights we afford to all persons.
What is the question exactly?
If I understood you, what's the distinction being made there between the rights of citizens and the rights of all persons?
Well, the question is, who are citizens and who are persons, right? Citizens, and it's not a question of franchise, right? Because citizens include women, right? Citizens include birthright citizenship. But persons would have been non-naturalized persons. And then, as we see soon, it expands to include corporations. So these are a broader protection of life, right, privileges and immunities of citizens, which is that clause kind of gets shriveled up after Slaughterhouse and Bradwell. But then the broader protection of life, liberty, and property attaches to persons, which is broader than citizenship. And then that struggle, talking about experimentation ongoing, that is the struggle and the unfolding of the 14th Amendment to, what is a person, what are these rights, what are life, liberty, and property. But I think you had a more specific question perhaps you wanted to get at. I think.
Kind of. I was mostly wondering, why do it? What's the point? What
So
distinction?
here's, begins with a technical answer and ends with John Bingham, from whom we should hear. You should all hear, because he was a very thoughtful lawyer. So Dred Scott says three things, from the absolutely preposterous, what Lincoln calls an astonisher in legal history, to the merely wrong. It says that free soil laws are unconstitutional. Congress can't prohibit slavery in certain territories, which the very first Congress did with George Washington's signature in the Northwest Ordinance, and the later Congress did with the Missouri Compromise, with John C. Calhoun and every other member of the cabinet saying, fine by us. This renders unconstitutional both actually Lincoln's policy of no slavery in the West, or even Stephen Douglas's let territories vote popular sovereignty. It's preposterous. It means that every free state is violating due process of law, that England is when it says, don't bring slaves here. It says a second thing, only blacks can be citizens. That's, I'm sorry, only whites can be citizens, excuse me. Blacks can't. Blacks descended from slaves actually technically can't. And the first sentence of the 14th Amendment changed that, but it also says only citizens have constitutional rights. Blacks basically can't be citizens, and only citizens have constitutional rights. Now, the framers of the 14th Amendment don't buy those propositions. So they say everyone's a citizen, okay, and then no state shall abridge these fundamental privileges and immunities of citizens. And that includes due process. So then why did they add due process? Because it includes everything, speech, press, petition, assembly. It also includes due process. Why did they add due process? And here's what Bingham says. He says, because we believe that even non-citizens are entitled to certain fair procedures. Here's what he says, quoting, in effect, the Old Testament, Exodus and Deuteronomy. He says, is it not essential to the unity of the people that the citizens of each state be entitled to all the privileges and immunities of citizens of the United States? Is it not essential that all persons, whether citizens or strangers, Donald Trump, within this land, have equal protection in every state in this union of the rights of life and liberty and property? And then he's objecting to an earlier version of another statute. Are we not committing the terrible enormity in distinguishing here in the laws in respect to life, liberty, and property between the citizen and the stranger within your gates? Because you were once strangers in a strange land, and so your Constitution says no person, not no citizen, shall be deprived of life, liberty, or property without due process of law. They are challenging very specifically Dred Scott's ruling that only citizens have constitutional rights. They say, actually, that's not true. Citizens have some constitutional rights, but there are broader, what Amy called human rights. The 13th Amendment talked about human rights, and Sumner believed in human rights. I think she invoked Sumner using the phrase human rights, and Person broadens it out, universalizes it.
Can I just say, where they were talking about? They were talking about the Chinese. If you read these debates, they keep on talking about, what about the Chinese? Because remember, there's a naturalization clause that it used to be only white people can naturalize, and then black people can naturalize. So you can have black people and white people, which puts the Chinese in this odd category. So when you look at these debates, they're saying, well, what about the Chinese? What about
Edgar
the Chinese?
Cowan.
So all persons, definitely, I'm not saying it's crafted to deal with the Chinese, but that's one of the categories of people that it applies to, because they are non-naturalizable people who are inhabiting the territory of the United States. So again, you have to think about the expansiveness in the framers, that they had the expansiveness really a human rights vision, right? That they're going to overthrow slavery in a broad, expansive vision. And then the struggle is how to define that and how to cabinet it in, and that's the unfolding jurisprudence of the Supreme Court. So I hope that helps answer it.
And Lincoln himself, this is so embarrassing, being surrounded, but Lincoln himself is emphatically opposed to the nativist elements of the society that create originally the American Party, the so-called Know-Nothing Party, whose basic idea is we're Native Americans and we don't like these foreigners, and Lincoln will have none of that. Now, he's gone, by the time these are emerging, but he does not want his Republican Party, Donald Trump, to be anti-foreigner.
And Native Americans are excluded.
Indians not taxed on both the Civil Rights Act of 1866 and the language, but they're tribal. They're seeing sort of a separate sovereignty.
Right.
And in Section 2 of the 13th Amendment, you'll also see the phrase Indians not taxed.
Professor Brown, you mentioned the 1960s as sort of a do-over and a second Reconstruction. Almost that the 14th Amendment wasn't enough and there was a need for new legislation.
A bit louder, just a little.
Yeah, we can't hear you too well, so.
There was a need for new legislation. Do you think today, with movements such as the Black Lives Matter movement, there's still a need to grow the legislation or just enforce these two acts better?
Well, that's a great question. So the question is whether today, with new movements like Black Lives Matter, are there enough laws on the books to address their concerns, or must there be new legislation? And what I would say is, I think it would be fabulous if the laws that already protect citizens against excessive police use of force were implemented. I also think that there's some utility in new legislation, but I don't necessarily think that it's needed. This is a problem of law on the ground, and law being in the hands of officers who have, tremendous discretion. It's really not a situation, for the most part, I think, where there needs to be some positive legislation. It's really an issue of human rights and buy-in to the norms that already exist.
But what about the Shelby case? Let's take voting, if you don't mind me picking up on your question. I mean, do we actually need now a new Voting Rights Act? Which is like
No, we need a new Supreme Court. I mean,
They're trying.
yeah.
So Sensenbrenner in today's New York Times has an op-ed saying we need a new Voting Rights Act. Now, here's a kick in the head. Here's a kick in the head. That Voting Rights Act that was partially invalidated, Section 4 of the Voting Rights Act of 1965, that by a 5-4 vote, a partisan vote, the Supreme Court invalidated in Shelby County, that law is still on the books, technically. And it need not be formally, I would argue, reenacted. It needs to simply be revived, and it might not be with a Republican-controlled House. It needs only to be revived. What that means is that, and there's now 4-4 on the Supreme Court, and so if that slot were to be filled by a nominee of President Obama's or President Clinton's, Hillary Clinton, that would be 5 votes.
Or President Sanders.
Well, that's not going to happen. But I read your. You don't need to reenact that law. The court could, on its own, reverse Shelby County, and that law springs back to life as a formal juridical proposition. So that's interesting for you to know.
You know,
We do just need a new, which just means we just need a new Supreme Court.
Right. The second Reconstruction, as the civil rights era is often called, did not actually produce any changes in the Constitution except the poll tax amendment, right? But that's pretty minor. What you needed was to just enforce what the Constitution we actually have and have had since Reconstruction. And it's probably the case now that there are plenty of laws on the books about equal treatment before the law and police brutality and all that kind of stuff, but they're not being enforced. If new laws might not be enforced very well either, that's the problem.
Gandhi was once asked, we do have, I think, a lot of good laws already on the books. Gandhi was once asked what he thought about Western civilization,
Yes.
and he paused and he said he thought it would be a good idea.
It's worth trying, right?
Yes, ma'am. Right here.
All this talk about abolishing slavery, what do you say to the 13th Amendment where it said except if a person is imprisoned? And now we have all these people who have been criminalized and now slavery is okay. So when I hear people say slavery is abolished, we have to realize we just evolved into a new slavery.
It's a brilliant point. The language of the 13th Amendment is lifted word for word, not from, as Sumner might have liked, the rights of man and his own experience in France, but it's word for word the Northwest Ordinance of the 1780s. You see it in that residue. So yeah, we have chain gangs and all the rest, and it's the new slavery, and I hear you. I think it's a very astute point.
You can also see it picked up in the second
Yeah,
section.
it's in the
14th
14th also. huh?
where the boundaries for the electorate are, there's an exception to a state's ability to disfranchise African Americans, and the exceptions for rebellion or other crime. And so right there is your big carve-out, which allows felon disfranchisement to exist today without invoking Section 2.
I want to ask our very distinguished law professors here a question. Section 2 has never been enforced, right? Even in the days of blatant disenfranchisement of black voters in the South, no Southern state was deprived of any of its representation in Congress, right? But here's my question. Unlikely, but could we not try to enforce it today? I mean, let's say Texas, which probably has, 30, 35 congressmen, under their new voter registration laws and this kind of thing, and voter ID laws, actually deprives a 3% of their population, or 6% of their population, of the right to vote. Couldn't we say, let's then take a couple of congressmen away from Texas, because they don't have all those people voting?
So this pulls together several of the strands already. Part of the reason Section 2 was Section 2 actually has been enforced, but in a way that most people don't recognize. It hasn't been enforced by a reduction of the number of seats a state has in the House of Representatives or in the Electoral College. And here's what happened. The framers of the 14th Amendment were not anticipating a 15th. They actually didn't prohibit disfranchisement. They just said, if you do, you have to pay a penalty. But by the time the next census rolled around, the 15th Amendment was on stream, and actually blacks were voting in the South as a condition of reentry to the Union and by dint of the 15th Amendment itself. And so, in the very first census passed after the 14th Amendment, it didn't really, basically there was, because of the 15th, and you didn't have redemption yet, you didn't have the unraveling of Reconstruction, it was being enforced. And here's the second, this is the point about bureaucratic capacity. You need an army of census takers and some really impressive, actually, political scientists to figure out who's not actually being allowed to vote, how you count who's being effectively disfranchised, if there's a poll tax or a literacy test or something, how do you actually figure out whether that's, in fact, an abridgment of the right to vote under Section 2? So it turns out, bureaucratically, Section 2 was hard to enforce in the censuses of 1870 and 1880. And after that, people kind of abandoned it. But here's the way in which it has been enforced. Because some people think the Warren Court just made up this right to vote. But in fact, the words the right to vote appear multiple times in the Constitution, beginning in Section 2 of the 14th Amendment. So here's the basis for the Supreme Court revolutionary 1960s Warren Court's right to vote jurisprudence. Here's what Section 2 says. If you disfranchise folks, you have to pay a certain apportionment penalty. Since you're not paying the apportionment penalty, everyone has to be enfranchised. And pretty much that's what we have today. So Section 2, in a weird way, does provide a strong foundation for the Warren Court's very robust right to vote jurisprudence.
All right, interesting.
Eric, you'll be glad to know that Bruce Ackerman, our colleagues Bruce Ackerman and Ian Ayers, have a Section 2 project
Yes.
underway.
I'm ready. Good, I'm ready for that.
got, here we are, right here. You got a mic?
Yes. So all of you are very distinguished historians whose job is to examine history and not necessarily predict the future. But obviously, as we mark the 150th anniversary of the ratification of the 14th Amendment, its legacy and the fight over it lives on. And you've brought up Shelby County, the Supreme Court case, and voter suppression as it's happening right now. There are a lot of things that are affecting, millions of people right now that are all tied up. And I'm wondering, given your incredible insights into American politics and American history and American constitutional law, what is the most effective way of, really reclaiming what the actual intent of the 14th Amendment was and making sure that people can vote and doing that kind of stuff? What is the most effective means of doing it? Because a lot of times, you can use the courts or something, but ultimately, at least in my view, I think public opinion, we're only really as good as public opinion. So what is the most effective way of moving forward and affecting real change in the future?
Elect people who will listen to the story. No, I'm just kidding.
It begins with public education. The Supreme Court justices did not go to college reading this book, and I did, and that's why I know that what they said was,
You should be on the Supreme Court then.
baloney, what this Shelby County is baloney, but these guys actually were taught by people who were taught by William Dunning. So they actually don't get the Reconstruction. They're channeling the founders and equal sovereignty and all this other stuff. So actually it does begin with people your age reading books like Eric's. In fact, because one day, yes, you will be, your generation will be on the Supreme Court. It actually does begin by telling your fellow citizens this right to vote stuff isn't made up. It really is in the Constitution. See, look, it says it 5 times, 14-2, 15, 19, 24, 26, 5 times you'll see the words the right to vote in this document. So it actually does begin with reclaiming the document and knowing its history. And if that's originalism, make the most of it.
Right. Anybody else want to?
Just one thought, which is, one possible risk of focusing on the 14th Amendment or any part of our constitutional text, most of the parts of our constitutional text that we do focus on, is that they look so old, right? They're from a long time ago. This is Eric's point. The civil rights movement of the Second Reconstruction doesn't produce constitutional change, one might say. And I would encourage you to not think of the Constitution as only a text. I mean, it's certainly a text, but it's also a set of social mobilizations. So I would say the civil rights movement, the Second Reconstruction, does change the Constitution. Radically transforms it. It's just not encoded in text.
Not the words.
It's
right.
encoded in a history and a tradition and a set of social mobilizations that are indelibly part of our constitutional tradition now. So now if that's what constitutions are, then you can go make constitutional law. Like, you don't need for the 9 or for the Congress. Like, you can do it yourself. I mean, you should get some friends, because it'll work better to get some friends on your side. But that's.
So this is a way of understanding the gay rights movement, for instance, and the incredible success over a very short period of time. It's people who are mobilized, who draw on the civil rights movement and what it's taught, and who demand full participation, full citizenship. That's people on the ground.
Yeah, I completely agree with that. And I sort of have been hoping that somebody would mobilize, would really start a big campaign. But they should have done it 2 years ago, but in this election, basically, use it or lose it. If you don't go out to vote, they're taking your right to vote away from you. And I think in this country, people are a little bit afraid of losing the right to vote. But it is happening. But I think that is a mobilizing idea, but the Democratic Party, as usual, doesn't know how to mobilize people, so, so it has never really done much with what is going on in these states of taking away the right to vote.
Just a quick point, but Donald Trump is mobilizing some people to go out to vote, which is a silver lining.
I think that the question about the relationship between constitutional text and social movements is what we're talking about here, and that. Right, and we have to look at the era of the New Deal, too. There was a constitutional transformation then, too, and it arose out of the mobilization of the labor movement, of working class, of working people, and then the civil rights movement, civil rights agitation, women's rights agitation, gay rights agitation. And so I think it's a signal thing to think about is Occupy Wall Street. And there was all this agitation, but what actually was it focusing on, and what rights was it claiming even as it was occupying? And so as you all agitate and mobilize, think about the politics of social movement building and its relationship to claiming rights and doing politics.
Could I just have a really quick anecdote on this voting question? Last fall, September, I was in Raleigh, North Carolina. They had the 150th anniversary of the original Freedmen's Convention, which occurred in September 1865. It originally met in an AME church, a black AME church in Raleigh. It's still the same church. We had this all-day celebration of the original Freedmen's Convention. That convention walked right up the street to the North Carolina Capitol at that time, 150 years ago, and presented a whole document of their rights, their liberties, and so on, particularly the right to vote. That state is undergoing, still undergoing, it was then, still is, the McCrory case. This is the governor of North Carolina trying to enforce really the most restrictive voter suppression law of all of the states that have done these things. And here's what happened. I brought it up in my talk, and this was a bipartisan. There were some Republicans there were Democrats there were blacks, there were whites. It was all to be a nice celebration. And I brought this thing up. I said, in your own state, folks, I'm just talking about living legacies, the McCrory case, at the coffee break, a couple of black bureaucrats, and I mean that positively, they work in the state government. They came over to me after in the coffee and they said, we don't really talk about that publicly. What? Well, we can't really, given our jobs. But you're right. We should be really fighting this. But you can't really do that publicly. I said, what? It's the right to vote. You can't do this publicly. But I understood their jobs were at stake. They're working for a Republican governor. They're working for a Republican agency now. So it's at that level where some of this is happening. Voter suppression is going on all over the country.
But even if it weren't going on, the question also is, we're going to go back to Citizens United. As long as, if you really want to get into this, as long as you have a political system that's dominated by corporate money, right, even if you have the right, how free is the execution of that right? You can vote, but, right, we have to think about the old money power in our political system. But I guess here I sound like Senator Sanders. So,
she took her Bernie button off. Bridget, we want to take one more question?
Just on mobilization, Martin King mobilized, but he actually mobilized claiming the text. He actually said there were promises made in this document. And he wouldn't have been able to give that same speech in South Africa at that time because the South African government didn't make those promises in its constitution. Its constitution actually said the basis of our system is racial separation. And the basis of this one is actually equality of many sorts. It doesn't even limit itself to equality. So actually, if you're going to mobilize, I think this is a rallying point for mobilization, and you should claim your history, all of it, including the history of Reconstruction and the progressive amendments, because actually the other folks on the other side claim the Constitution. The problem is they haven't read it and they don't know its history. It's actually a radical document for its time in 1787, and all the amendments, with the exception of Prohibition, basically, which didn't work, added to liberty and equality, and it's actually, it should, it's like what Gandhi said about Western civilization, it sounds like a good idea. The stuff in here that's already in here is pretty good and because this history is actually correct in a way that the Dunning School history actually isn't. And that is power to actually have the history of the 13th, 14th, and 15th Amendments on our side.
All right.
I don't think we can have any more questions after that.
All right.
Akhil reminded me of that great Lincoln quote from 1864. We all declare for liberty.
Mm-hmm.
We just don't mean the same thing. They do read the Constitution. Some of them do. Well, okay.
Now that's why I kept saying Donald Trump. He hasn't.
Well, no, I'm not talking. Trump hasn't read anything.
I think if he did, it wouldn't make much difference to him.
Yes.
But we can wield this against him.
I want to thank this panel. It's been a lot of fun. And I hope
Okay, thank you.